we go to Siren, Wisconsin for a status conference. 30-year-old Nicholas Butkas Taft has been charged with criminal trespass, criminal damage to property, resisting or obstructing an officer, and disorderly conduct. A year earlier, around 2 a.m., police say Butkas Taft broke into a local home. The couple who lived there heard him and called police. When officers arrived, they found Butkas Taft bleeding from injuries he sustained while climbing into the house through a window. Butkas Taft initially resisted officers, but was eventually taken into custody. He was released on a $500 personal recognizance bond with the conditions that he have no contact with the victims and pay restitution for the damage caused to their home. But when Butkas Taft failed to appear in court, his bond was raised to $1,000 and a warrant was issued for his arrest. He was picked up about a month later. And today, Butkas Taft appears from the county jail before Judge Melissa Mogan to hear if his bond will be revoked. He's represented by attorney Zachary Fisher.
Mr. Butkas Taft, why weren't you in court?
Your Honor, I take full responsibility for it, but it was an honest mistake. My kids were home from school that day, so I just lost track of time. It was unintentional, but it was my responsibility to make that court date.
When did you find out you had a warrant? You should have found out right away.
Yeah, I was aware of the warrant. My train of thought was, I'm the only one working, my family. I just wanted to keep going to work and then pay that cash, the $1,000 cash bond, so we could move forward with this case. Like Mr. Fisher said.
I don't believe it.
Okay.
Your hearing was on February 6th. You knew you had a warrant.
I know.
You weren't picked up until March 11th, over a month. Don't be giving me some story about you wanted to save up that $1,000. That's blarney. That's a story. That's made up. You could have turned yourself in and you could have said, you know what, Judge, I messed up. You could have done that and you could have done what you're doing now. Baloney. Baloney right now. I don't believe you. So in fact, I'm raising bail to $2,000. You had from February 6th until March 11th to figure it out, to turn yourself in, to have your attorney ask the court for leniency, like you're doing now. But you didn't. You didn't. You should have thought about that on February 6th. You should have thought about that on February 7th. You should have thought about that on February 8th or 9th or 10th or 11th or 12th or 13th, 14th, 15th, 16th, or so on. You should have thought about that. But now you are, because you are in jail. So now you got to figure out how to come up with $2,000.
Bond was set at $2,000. And 2 months later, Butkas Taft accepted a deal where, in exchange for pleading guilty to criminal trespass, criminal damage to property, and disorderly conduct, the resisting arrest charge was dropped. For the criminal damage charge, he was given a deferred sentence of 18 months. For the remaining charges, he was sentenced to 18 months probation and must pay $11,720 in restitution to the victims. Next, we head to Trenton, Michigan for a probation violation hearing. 52-year-old James Adams has pled guilty to no dog license and letting his dog run at large. 8 months earlier, after Adams failed to get his dog vaccinated for rabies, he was cited for allowing it to run freely without a license. He pled guilty and was sentenced to 12 months probation, 5 days of community service, and ordered to pay a fine of $615. He was also given a month to get his dog a rabies vaccine and obtain a license. When Adams failed to do either of these things, he was ordered to appear in court before Judge Michael McNally to hear if his probation will be revoked. He appears without an attorney.
I ordered you to have this dog licensed. It came to my attention 2 weeks ago that you didn't. Hang on. It's very simple, Mr. Adams. I can't believe we're still going through this.
He's gonna die. You're gonna kill my dog.
I'm not gonna kill your dog.
If he gets that vaccine, he will die. He almost died before.
So,
should I just put a bullet and go home and put a bullet in his head?
hang on a second.
I mean, I can do that. Just get it over with. If that's the ruling, then I'll just go home and put a bullet in his head. That way he doesn't have to suffer. You ought to see what he went through. It was horrible.
Listen.
And now you want to kill my dog? And who's going to be accountable for that? You can't have it.
Judge McNally uses his gavel to restore order.
I tried to do him all.
Listen.
Listen. He cannot have the shot.
Listen.
We'll die.
Listen.
I have the proof for it. He cannot have the shot. I was not negligent. I have been trying and trying and trying. I don't know what else to do other than kill him.
Nobody wants your dog to
Well,
die.
if you vaccinate him, he's pretty much dead.
Listen.
The doctors are recommending for me not to do it.
In order for a dog to be licensed, the dog has to have its shots. It has to be vaccinated. Now, what you're saying to me is, be a god, be a king, and just say the hell with their ordinance. But that's not what judges do.
Your Honor.
I want you to listen to me for a second. That's what you want me to do. I can't do that.
The judge brings in prosecutor Caitlin Foley Carter, who's been in touch with state legislators about the ordinance.
Ms. Foley Carter.
The state reiterated our position is that there are no exceptions or exemptions to adopting the rabies vaccination.
And I'm supposed to let this dog run around and bite somebody? You know, people fight, dogs bite.
You can't amend this and try to fix it for a remedy? Because there needs to be...
Fix it for a remedy. What, ignore the Brownstown laws?
It's 106 years old.
And you signed a plea agreement saying must register and obtain licenses for all animals in the home within 30 days. That's in part and part. I ordered that. Do it. I am not about to carve out an exception for you or anybody else or myself. Now, I'm not going to argue with you. You want to get your lawyer here and you want to contest this, you feel free. I'll give you an opportunity. I'll adjourn it a week. But my patience is running thin. So nobody wants your dog to die, Mr. Adams.
He's got a really good chance to die.
A week later, Adams returned with his attorney and pled guilty. He was ordered to pay a fine of $125 and agreed to get his dog a rabies shot, which he did. His dog is fine. Next, we head to Houston, Texas for a probable cause hearing. 38-year-old Cody Fritter has been charged with harassment and, in a separate case, assault on a household member. 5 days earlier, police say Fritter got into a physical altercation with his live-in girlfriend after she failed to put away his socks. Investigators say they also discovered several harassing voicemails and text messages sent from Fritter to the alleged victim. Fritter was arrested and released on $50,000 bond with several conditions, including that he have no contact with the alleged victim and that he abstained from drugs and alcohol. Today, he appears before Judge David Fleischer to discuss next steps in the harassment case. Fritter is represented by attorney Abel Izagira.
Mr. Fritter, you're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause.
Judge Fleischer asks the prosecutor to review the charges.
In the voicemails, the defendant curses at her, asking, "Where are you? Why the are you at work?" and calling her various names. Additionally, the complainant showed the officer text messages of the defendant telling the complaining witness, "Kill yourself and I want to watch you suffocate," and "Your family hates you." The complaining witness indicated that the continual harassment is making her fear him even more.
I see that he has also picked up a felony assault against this complaining witness as well.
Yes, sir.
Okay. What happened in that one?
The complaining witness advised that the defendant came home upset about socks not being in the closet. The defendant punched the complaining witness with a closed fist on her foot twice, on her right thigh, and twice on her left thigh, causing pain. The complaining witness advised that the defendant grabbed her by the arm and forcefully shoved her out of the house, throwing her on the porch. The officers observed purple and green bruises on her arm, foot, and her legs.
You know, Mr. Fritter, let me tell you something now. You scare me. And you scare me something good. Look at me! Can you imagine what life is like when someone has to walk on eggshells because they have the fear that if they make someone mad in the smallest respect of having socks not in the damn drawer, they're liable to get a beating? Can you imagine what life is like to live with that kind of fear? You're gonna live it with me now. Because one false move, I'm gonna make your bond so high your head will spontaneously combust. Do you understand?
Yes.
I'm entering what's called a magistrate's order of emergency protection. This is a court order that identifies her as a protected individual. You're not to have any kind of communication whatsoever. You will not have any threatening or harassing contact. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what she perceives. So, if I go like this, is that threatening or harassing? It most certainly is. Mr. Fritter, I will do everything in my power to protect every single person in this county. And I don't care if you're kicking, screaming, crying, because you go to jail and don't have anyone to bond you out.
And with that, Judge Fleischer released Fritter with the same bond conditions: no contact with the alleged victim and no use of drugs or alcohol.
Mr. Fritter, if you fail to live up to these bond conditions, I'm just going to elect you. That's it. And if I get one, and I mean one breath that she's been mistreated in any way, shape, or fashion, holy freaking moly.
A month later, Fritter pled guilty to assault on a household member, and the harassment case was dismissed. He was given deferred adjudication, which means if he completes 2 years of probation without any violations, the assault case will also be dismissed. Next, we go to San Antonio, Texas for a probation revocation hearing. 25-year-old Deandre Lemont Coleman has been charged with assault against a family member. 8 years earlier, Coleman got into an altercation with his now ex. He was arrested, charged, and granted deferred adjudication, where if he followed the conditions of his probation for a year, the charges would be dropped. But 8 months later, Coleman tested positive for cocaine and marijuana, violating one of the court-ordered conditions, and a warrant was issued for his arrest. 6 years later, he was taken into custody, and today, Coleman, who's chosen to wear a mask to the proceeding, appears before Judge Rosie Speedland Gonzalez to hear if his probation will be revoked. He's represented by attorney Cornelius Cox. The prosecutor is Taryn Delgado.
Please raise your right hand, Mr. Coleman. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury? Should you make a false statement, or should you lie to the court?
Yes, ma'am.
Okay, he swears to tell the truth. You may put your hand down.
My client, we invoke his right to remain silent at this time.
Okay, that's your prerogative. So, Mr. Coleman, the state is alleging that you violated condition number 2 by testing positive for marijuana. Is that true or not true?
We stand mute to all the allegations.
Mr. Coleman, the state is alleging that you violated condition number 2. They state that you used cocaine.
With the defendant choosing to exercise his Fifth Amendment right, the judge moves on.
Mr. Cox, I need you to review the proffered exhibit, and then I'll hear any objections that you may have to that exhibit.
Thank you, Judge. One more thing, Judge. I'm not sure if this session is on YouTube.
It is.
My client objects to it.
Well, then he already consented to us using Zoom and the video conference and everything. It's public courts. So the public is entitled to watch, just like everybody watches your friend, Judge Boyd, Mr. Cox.
The judge is referring to Bexar County Judge Stephanie Boyd.
I'm sure you don't go in there objecting to it being published in there. So it's the same rules in here, Mr. Cox. All right? His request is denied.
Okay, but the court making a reference to what I may or may not do in other court, I don't
Mr. Cox, we're not going to entertain that. I'm just pointing out an inconsistency in your request. So, your request is denied. You can take 5 minutes to review the proffered exhibit. Everyone is excused for now. The court sits in recess.
5 minutes later, Judge Speedland Gonzalez moves to close out the topic.
For the record, I did contact General Counsel for County Courts at Law to get an opinion on my denial of Mr. Cox's request to stop the YouTube and to stop the Zoom. And my denial of that request stands based on the legal opinion tendered to me by our general counsel. So we're going to proceed, Mr. Cox.
And if I may, Judge, my position at this point, Judge, is that based on the court's comment about my conduct in another court, I'm going to request that the court recuses itself. I don't have an opportunity at this point to file a written motion, but I'm going to make an oral request that based on the court's comment, I don't think that...
We got your objection. You repeating it 2, 3, 4 times, Mr. Cox. Stop right there. Stop right there, Mr. Cox, or I will hold you in contempt of court. My statement about your behavior in another court was not a statement on the facts of this case. You have not established any predicate to ask that I be recused from this case. Your request is denied. We're going to proceed.
That's fine, Judge.
It doesn't matter if it's fine to you or not, Mr. Cox. I'm going to direct you now to stop your sidebar comments and allow this proceeding to continue. And if you step out of line one more time, Mr. Cox, with your comments, I will hold you in contempt of court, and I'll ask Deputy Ramos to take you into custody. Do you understand me, sir?
I understand you, Judge.
Thank you very much, Mr. Cox.
I speak to it.
No, Mr. Cox. You may proceed, Mr. Delgado.
In the end, the judge ruled that Coleman did violate his probation, and his deferred adjudication was revoked. He was sentenced to a year in jail, with credit for 79 days' time served. Coleman served the remainder of his sentence and was released. Next, we go to Trenton, Michigan for an arraignment. 43-year-old Jason Romphf has been charged with possession and use of drug paraphernalia and possession of a controlled substance. 2 years earlier, police say Romphf was carrying a small amount of crack cocaine and a homemade pipe. Romphf also has an open case from 7 years earlier, when he was cited for a civil bicycle violation and apparently still owes the court $189. For the drug charge, Romphf was released on a $2,500 personal bond. Later, when he failed to appear for a hearing, a warrant was issued for his arrest. Today, Romphf appears from the county jail before Judge Michael McNally to hear if he'll be given a new bond. He's represented by attorney Mike Baldwin.
Judge, for purposes of arraignment, my client stands mute, waits formal reading of the general information.
Not guilty pleas are entered, including on the show cause.
I inform my client that that is in default and that it needs to be addressed.
Well, it's been in default for 7 years. Where do you live?
Creekside Estates.
How far is that from here?
Like, I can throw a rock in it from here.
Why haven't you shown up here in 7 years?
I didn't know I had a bike infraction 7 years ago.
The police stopped you in 22, and your license reflected that you were living on Pennsylvania. Now you're saying Creeks.
Sorry.
You're supposed to update your address with the Secretary of State. So I don't know if you were. Sure.
Sorry, sir.
You haven't been here in 7 years. Where do you work at?
Maintenance at Creekside Estates.
Tell me something. Why don't you think you have to show up in court? I want to know. So this.
I totally forgot about it. I'm sorry, Your Honor.
Totally forgot.
I swear.
Totally and completely forgot. So now you've got yourself in a predicament here. I hope you got somebody that's going to help you, because I'm not. Because you've been blowing us off for 7 years on one of these cases and 2.5 years on the other. See, why do you think you can blow courts off like this?
It's not that, sir. It's just I have no money. I just started working for Creekside. I have no money.
Nobody said anything about money. Your ticket didn't say show up if you have money. Your ticket didn't say show up if you're working. Don't show up if you're not working. Don't show up if you don't have money. You cannot show this kind of lack of respect for courts.
And with that, the judge sets a new bond in the case.
So you need to come up with 3,500, 10% plus the 189 or 539. Wish you well. Hope you can. If not, I'm sorry. Maybe you'll learn the lesson. I doubt it, but possibly you will. Good luck to you.
Romphf paid the $189 for the bike infraction, and after spending 26 days in jail, he pled guilty to drug possession and was sentenced to time served. The paraphernalia charge was dismissed, and his cases are now